Well, I think we should go ahead and get started. Thank you everyone for coming. Thank you, Mr. Linzey, for being here. I'm very excited for this today. By way of introduction, I wanted to say that our speaker tonight, Thomas Linzey, is a cum laude graduate of Widener Law School and is licensed to practice law in Pennsylvania and admitted to practice in the United States Supreme Court, several of the federal circuit courts, and the U.S. District Court for the Western and Middle Districts of Pennsylvania. Mr. Linzey currently serves as Senior Legal Counsel with the Center for Democratic and Environmental Rights, an organization committed to globally advancing environmental rights. He is the co-founder of the Community Environmental Legal Defense Fund. Sorry, I'm omitting people. And is widely recognized as the founder of the contemporary community rights movement, which has resulted in the adoption of several hundred municipal laws across the United States. He assisted the Ecuadorian Constitutional Assembly in 2008 to adopt the world's first constitution recognizing the independently enforceable rights of ecosystems and is a frequent lecturer at conferences across the country. He has won numerous awards and has had his work featured in the New York Times, the Los Angeles Times, Mother Jones, and The Nation magazine. He was named in 2007 as one of Forbes magazine's top 10 revolutionaries, and in 2018, Mr. Linzey was named as one of the top 400 environmentalists of the last 200 years. And with that, I will turn it over to Mr. Linzey.
Great. Thanks, Aubrey. And at the outset, I just wanted to thank Aubrey and the Environmental Law Society for making this event happen today. It was also my pleasure to speak a couple weeks ago at the university to the Society of Environmental Advocates, the undergraduate environmental law group there as part of the So I'm back again, in other words. So I know people are probably tired of staring at screens, and so I'm going to try to make this as interesting as I can. And in fact, due to the source material, I don't think that's going to be difficult. But we're here to talk about recognizing human civil rights type protections for nature. So just in shorthand, civil rights for nature and ecosystems. And it kind of bends our brains sometimes to talk about civil rights protections for ecosystems or nature. We're used to talking about constitutional rights and civil rights for people, like due process and equal protection and free speech and freedom of assembly and those types of things. Constitutional rights found both at the state constitutional level as well as the federal constitutional level. So we're used to talking about civil rights for people or constitutional rights for people. But we're not used to talking about constitutional or civil rights for nature or ecosystems. And it kind of bends our brain. It's kind of hard to get it out of our mouths sometimes to talk about civil rights for nature. But that's what we're going to be talking about today. And we wouldn't be talking about this concept of constitutional or civil rights for nature and ecosystems if we had an existing system of environmental protection that worked. So if we had an existing system of environmental protection that worked, we wouldn't be talking about this kind of, what was 20 years ago, a fringe kind of idea about rights for nature, civil rights for nature and ecosystems. And, you know, I sit here today talking with you as somebody that had tried to make that existing system of environmental protection work. And in fact, most of my environmental colleagues, legal colleagues in the environmental law community, have also tried to make that existing system of environmental law work. For me, that consisted of about 10 years of work trying to appeal permits. So permits issued by state agencies to corporations or other industries to do a specific project or activity in a community. And environmental law today basically is the same as it was when I started my journey back in 1995, which is it's focused almost exclusively on this regulatory mechanism of permits issued by state agencies. Environmental lawyers then come in and look at the permit application that was filed by the corporation or other business entity that filed for the permit. We then compare that against the environmental regulations at the state level that govern the issuance of that permit, i.e. what it has to have in it. And we end up most times in front of administrative law judges or in courts arguing to judges that something was missing from the permit application that was put in by the corporation for that specific activity. So in essence, we would end up over that 10-year period of time arguing to judges that something was missing, that the state made a mistake, that the environmental agency made a mistake, that there was an error committed, that the permit never should have been issued because there was a gap or omission or deficiency in the permit application, and therefore issuance of the permit should be overturned. And just to get very specific, and folks here may have worked on some of these issues as interns or other volunteer work that they've done with organizations, but we ended up arguing over whether a permit application had been signed by the right people, or whether there was a correct bond amount given for fixing the roads, for roads that would feed that particular activity or project, or that a water study was done, but it was outdated. It was 10 or 20 years old and should have been replaced by an updated study. So in essence, we'd be arguing to a judge, judge under Section 24 of the Clean Streams Law, Section 2, little c, little I, little Roman numeral 2, little e, little 2, little I, little e, something was missing. That it wasn't, that the permit application wasn't complete, and therefore that the permit should be nullified or overturned or withdrawn. And for the most part, when we made those arguments, the judges would agree with us that something was missing. And that's not because we had, a golden tongue arguing to the judge or came up with arguments that nobody else could come up with. It's just the fact that in the United States today, over 90% of all permits aren't appealed at all, just because the communities that are confronted with these projects and activities and these permits just don't have the resources to actually appeal those permits. So most of the permits go unappealed for these projects and activities that communities don't want. So just by showing up sometimes is enough, that you get into court, you make the arguments about these gaps, omissions, and deficiencies, and a lot of times that was enough to throw the permit out. But what would happen next was troubling to us. And one of the things that happened next was that we would have a victory party. So we would go back to the home of the leader of the community group that we were representing in the permit appeal. We would have some beer and some wine, snacks, and everybody would congratulate each other for winning the permit appeal, and therefore that they weren't going to get the toxic waste incinerator, the hog factory farm, the frack wastewater injection well, the frack well, whatever the individual single harm was that the community was trying to stop. And we would all congratulate ourselves on finding a judge that listened, finding a lawyer that could speak somewhat intelligently about the case, and coming up with the arguments to get the permit thrown out. Well, what would happen next? It was pretty logical looking back on it from Monday morning quarterbacking at this point, but the corporation would come back. And when the corporate permittee came back, they would thank us for finding the gaps, omissions, and deficiencies that we had found within the permit application to throw the permit out, mostly because, and true story, we were up against some of the largest corporations in the world, like Waste Management Corporation, Monsanto Corporation, you name it. And after the arguments where we had prevailed, sometimes I would have the lawyers for those corporations come over to me and thank me for finding those gaps, omissions, and deficiencies in the permit applications, so that they could go back, charge the corporations more hours, bill them more hours to fill in those gaps, omissions, and deficiencies. So for purposes of the talks, especially during this tour that we're giving for universities and law schools, is that I've shortened the story down, but sometimes this went on for 7, 8, 10 rounds, 4, 5, 6 years, kind of endless back and forth over gaps, omissions, and deficiencies. But in the end, we found that we weren't really stopping anything from being cited, from being permitted in these places. So they were getting the toxic waste incinerators, they were getting the hog factory farms, they were getting whatever we had tried to stop through the permit appeal process. And when the corporation would come back, the corporation would come back in with a new and improved permit application, and the community group would come to us and they'd say, Mr. Linzey, we need you to do that jujitsu you did the last time around to get this permit kicked because we still don't want this project in our community. It was very frustrating to look back at them and say, well, we're sorry, there's nothing we can do for you because all the levers are gone. All the environmental levers are gone that we had originally in the regulatory system and process to find those gaps, omissions, and deficiencies. And so we had to apologize. We started out by apologizing, saying, well, there's nothing we can do for you anymore because we don't have those levers anymore to try to stop this permit from being issued or from going into effect. what happened to me during that time personally was that we found ourselves kind of doing nothing more than helping corporations write better permit applications. And in terms of re-examining the system of environmental law we have in the United States, and the reason why things are getting worse, both in this country as well as abroad and globally, is that we've kind of been stuck in this system where the regulated industries write the regulations. So we first of all, we have to think about that, about who's writing the regulations in the first place that carry out the state or federal environmental laws. I worked in the Capitol in Pennsylvania for a while with the legislature. I actually saw legislation and regulations being handed off to the relevant officials to be passed, written by the corporations or the industries themselves, just kind of like a standard operating practice. But if we think that we're actually going to stop anything using regulations that were written by the very corporations that ostensibly those regulations are supposed to regulate, why would the corporations put anything in those regulations that would assist communities to actually stop the projects that they're trying to put in the first place? It's almost like a hamster wheel, or people that have been at county fairs playing a game called whack-a-mole. The mole comes up, you hit it with a hammer, it goes down. It's not the most nonviolent game, but other moles then come up, and eventually at a while, there's too many moles to whack. And you're left in a position where when we were trying to stop one frack well or one factory farm, 8 more would be proposed in the counties next door. And so it was an endless battle to try to stop these things through a system in which our activism script is basically written by the very corporations that those regulations are supposed to be regulated. So when we go into court to appeal permits that have been issued by the state, it's basically the bottom of the 8th inning or top of the 9th inning already. We have both hands tied behind our back, and we're fighting under a script that someone else wrote for us. Yet we expect our activism to make a difference in terms of canceling or vetoing out these dangerous projects that come into the communities. And someone said something to me back then that didn't make much sense until 10 years later. We at least thought we were costing the corporations money, so that if we hauled them into court, Chemical Waste Management hauled them into court to appeal a permit, we were at least costing them money, that they had to hire lawyers and law firms to actually go on the defense to defend these permits. It was then that we learned that the monies that the corporations spend on the defense of the permits is actually tax deductible. It's a reasonable and necessary business expense under the tax code, can be written off by the corporations that spend the money to actually hire the law firms to defend against those permit challenges. And then the second thing that was said to me about 10 years that I didn't understand for about 10 years was that this person said to us, the only thing that environmental regulations regulate are environmentalists, that they regulate how we fight when these projects come into our communities, that there's a script that's written and that we follow it. And that script is not ours. That script is the corporations of the regulated industry. And we follow it, which means we're basically regulated by that set of environmental regulations, which kind of controls at this point voluntarily. We choose to be controlled by them about how we fight specific projects coming into those communities at risk. And so it should come as no surprise, and after doing the work for 10 years, trying to enforce existing environmental regulations through this process, that things are worse now, 40 years after the major environmental laws were passed, by almost every major environmental statistic today, than they were 40 years ago, before the major environmental laws were passed. And that usually draws some, shocked reactions from folks that we speak to. But everything from climate change to how much stuff we continue to put in the atmosphere, combined with the fact that we all carry around 700 synthetic chemicals of the 80,000 synthetic chemicals that are now circulating in society. But you name it, by almost every major environmental statistic, things are worse now than they were 40 years ago when the major environmental laws were passed. So once we get to that part of the talk, a lot of people say, well, so what? It's the system that we have. And in fact, after 10 years of doing the work in the environmental regulatory agencies and appealing permits, we said, so what? It's the only system we have. We have to try to make it work. But the losing proposition that we were involved in, even though our win-loss record on paper was like 120-4, we were winning on paper at least, all of these permit appeals in front of these administrative law judges bore really no resemblance between our win-loss record on paper and what was actually happening in the field, where the communities were actually getting the factory farm or the fracked wastewater injection well, or whatever the project was that they were trying to stop. There was a political community that didn't seem to care. We got invited to the White House one year by Al Gore as one of the best environmental law firms in the nation. We got the funding, we got the recognition, we got all the stuff that people crave about success, but it really had nothing to do. It was disconnected from what was actually happening on the ground, where these communities were actually getting shell-shocked with these projects coming in. So all to say, it led us to re-examine what environmental law was. And in fact, led us to re-examine how Western law, which is the system that we're under, a European system of law, or Western system of law, how that Western system of law actually views nature. And what the difference is between how a Western system of law views nature and how indigenous cultures traditionally view nature and ecosystems. And so when we start looking at that Western system of law, European system of law, it's important to understand that the Western system of law basically sees nature as a dead thing, as an inanimate thing, something to be used by people, but not something that's alive, that the earth is not alive. There is no such thing as Gaia, the Gaia hypothesis. There is no such thing. The earth is not alive. The woods are not alive. It's all inanimate. And it's basically there for use of humans. That's the Western system of law's kind of view of nature. And contrast that to indigenous visions of nature, who talk about nature in much different terms, as being animated, as being alive, as being relatives, as being part of the same system. So you have the Ponca Nation, for example, in Oklahoma, that speaks about speaking for those without voices. So nature, ecosystems, animals. You have the Chippewa, the White Earth Nation in Minnesota, that talks about the flying people and the swimming people and the singing people, these elements of nature that they see as alive and animated. The Yurok Nation in California talks about the Klamath River as being a living being, a relative of the people of the Yurok Nation. So you have a much different understanding between these indigenous cultures, how they treated and see nature culturally, and how a Western system or European system of law sees nature as kind of a dead thing, an inanimate thing. And I think the best way to explain that in shorthand is really Sir Francis Bacon, of all people. Sir Francis Bacon, the English philosopher, he once said that the job of humanity was to torture nature on a rack to extract her secrets. So to torture nature on a rack being the medieval torture instrument for people, where they would stretch you out until your bones would pull apart and ligaments would separate. And he said that we needed to torture nature on a rack. So I think the difference between torturing nature on a rack and seeing nature as a relative, or the flying people, swimming people, singing people, pretty much self-explanatory, but that's the worldview difference between those two systems. And our environmental regulatory system, unfortunately, treats nature and ecosystems not only as inanimate, but as property to be owned. So in our system, the more property or ecosystems that you can own, the more you can legally destroy under the law. This bundle of rights, we talk about property 101 and property 201. We talk about bundle of rights. I think it was the first thing said in property class back when I was in law school. It's a property ownership is a bundle of rights. Well, one of those rights within the bundle is the right to destroy. That's a power of the property owner. It's a legal right of the property owner. And so the more property you can own, the more you can destroy. The more ecosystems you own, the more you can destroy. That's kind of how the system is set up. And unfortunately, because nature is treated as property, we have property rights written directly into the US Constitution. So there are constitutional protections against takings of property. And because nature is property, you can also say it this way, there are constitutional protections against protecting nature through adopting regulations or laws that stop the destruction or exploitation of nature, because eventually you begin to interfere with people's constitutionally protected property rights. That's how the system is set up. So in law school, in environmental law class, you talk about takings, regulatory takings, that there can be environmental regulations that are so onerous on the property owner that it actually affects the takings, and then the government has to pay the property owner for the value of those takings. So it's a dangerous mix when nature is property, but you have a constitutional structure that actually protects that property from governmental quote unquote intrusion in the form of environmental regulations or laws. Okay, so what, right? That's how the systems are set up, the difference between the systems. Our journey, my journey, had to do with trying to figure out whether there were other models of environmental protection that were not anchored in this property concept. And we ran across a law review article from 1972, ancient history, 1972, but written by Christopher Stone, who's a University of Southern California law professor. He still teaches. And Christopher Stone wrote a law review article entitled, "Should Trees Have Standing?" And usually when I'm talking to undergraduate class, we need to explain standing. We probably don't need to do that today. But basically, your ability to access the courts by having a physical harm of some kind that you can actually get into the courthouse doors to have a case, to prosecute a case as a plaintiff. Well, Christopher Stone, he had this law class that he taught after lunch and everybody was falling asleep. And so Christopher Stone decided to inject this concept of nature having standing, i.e. rivers being able to go into court, forests being able to go into court, basically people being guardians or trustees for those natural systems to go into court on their behalf, so that the court proceedings, the lawsuit, would not just look at the people's injury or harm, but would look at the harm directly to the mountain or to the rivers or to the ecosystem that those people were trying to protect. And Christopher Stone injected that idea into a law school class, again, after lunch. Kids were sleepy. And it eventually turned into a law review article called "Should Trees Have Standing?" That law review article entered kind of a perfect storm because that same year there was a case working its way up in the US Supreme Court that dealt with the standing of an environmental group to try to stop a development from going forward. So the development in question back in '72 was taking place in Mineral King Valley for folks in California. So for folks who don't know where that is, start out in San Francisco, head directly east. Right before you hit Nevada, you'll come to a place known as Mineral King Valley. It's now Sequoia National National Park. And it's there that Walt Disney wanted to build this huge ski resort. So how big was the ski resort? Well, 1.7 million annual visitors, 20,000 skiers, bigger than Disneyland. That's usually all we need to say about it. Bigger than Disneyland in this place that eventually became Sequoia National Forest. The Sierra Club didn't want to see the forest destroyed. They sued to stop it. The lower courts dismissed the Sierra Club, said you don't have standing. You haven't shown an injury that allows you to be in court in the first place, so we're going to dismiss you out of this case. It was appealed up to the US Supreme Court. And in the US Supreme Court, the court also dismissed the case, finding that the Sierra Club didn't have standing to bring the action. The difference between that environmental law case and all the other environmental law cases that have gone to die in front of the US Supreme Court, and there will be more over the next 10 years, was that Justice William O. Douglas, one of the most progressive environmental Supreme Court justices ever, wrote a dissenting opinion, which has become like, something that you print off and frame on the walls. Because what Justice William O. Douglas did was he took Christopher Stone's law review article and he wrote it into his dissent. And he said, what would it look like if trees, in this case, if Mineral King Valley, Mineral King itself had standing? Mineral King instead of the Sierra Club. The difference, there would be a huge difference, because it wouldn't just be looking at injury or standing on behalf of the members of the Sierra Club that would have to prove it to get standing, but that nature itself could bring the case with guardians and trustees as people. And that the case would be prosecuted much differently, because standing would be found by those natural ecosystems that would be damaged or destroyed by this particular project. And so I just wanted to read in the short time that we have just one little quote from that case. This is from his dissent, Justice William O. Douglas. He wrote, "The critical question of standing would be simplified and also put neatly in focus if we fashioned a federal rule that allowed environmental issues to be litigated before federal agencies or federal courts in the name of the inanimate object about to be despoiled, defaced, or invaded by roads and bulldozers, contemporary public concern for protecting nature's ecological equilibrium, probably the only time you're going to see that phrase in a Supreme Court opinion, at least in the short term, should lead to the conferral of standing upon environmental objects to sue for their own preservation. The suit would therefore be more properly labeled as Mineral King versus Morton. So instead of the Sierra Club as a plaintiff, Mineral King itself, the valley, the forest as a plaintiff, thus enabling standing to accrue to the natural system to a greater extent than to the people within the Sierra Club that were trying to bring the action. So that was Justice William O. Douglas's dissent. So Justice William O. Douglas writes this dissent. What happens? Well, people read it. Some environmental lawyers picked it up. We've done some extensive research over the past 6 months trying to track down a lot of these cases, but some lawyers decided to actually try it on behalf of CDER in Florida, for example, in 1994 and 2005, on behalf of loggerhead turtles. Loggerhead turtles filed a lawsuit in Volusia County, Florida, against a county that was attempting to light the beaches, which interferes with the progress of the loggerhead turtles and laying of eggs, and the baby turtles making it to the ocean. Those cases didn't really get too far because basically the courts held that the Endangered Species Act, in this case, defined persons as human beings, Homo sapiens, and that therefore these plaintiffs, which were animals, couldn't bring suit on their own. And so kind of things stalled between Justice William O. Douglas's dissent and then something that happened in Pennsylvania back in 2006, which was a little community in Tamaqua Borough decided that they didn't want to be a toilet for PCB-laden dredge coming in from the Delaware River. So just to set the stage, you have the governors of Pennsylvania and Delaware who decided to dredge the Delaware River to make it deeper for commercial traffic, barge and other traffic coming down the river. And when they shoveled the dredge out, they realized and found from testing that it was full of PCBs, polychlorinated biphenyls. So some of the most toxic synthetic stuff that's ever been discovered, PCBs. We're still living with the tragedy of the widespread use in the 50s and 60s. So they said to themselves, where do we put this stuff? Let's put it in the poorest community we can find, basically, paraphrasing here, what the governors actually talked about. But let's put it in this place called Tamaqua Borough, which is northwest of Philadelphia. It's 7,000 people. It's relatively small. And it's an old mine community, deep mining, that has open mine pits throughout the community. And the idea was to take the PCB-laden dredge and dump it into the mine pits, thereby making Tamaqua this big toilet. The people of Tamaqua said, we don't want that. We don't want to be a toilet. We don't want that to happen here, and asked us to draft a law dealing with a ban or a veto on certain that dredge product or other toxics coming into the community. We did that, and then asked about drafting an ordinance that would protect the Little Schuylkill River, which provides drinking water to Philadelphia, the Wabash and Panther Creeks, basically the waterways within the community that could be impacted by the PCB-laden dredge coming in. And we have been talking to them about working around this rights of nature concept to take it from just being an idea to being something that was actually embedded in law. And we drafted a local law that actually recognized that waterways within the borough had the right to exist, flourish, and naturally evolve. So constitutional type standards for waterways within this little borough. And I think to our amazement, the Borough Council went ahead and passed the law. And in doing so, they became the first community in the world to actually recognize legally enforceable rights for ecosystems. In this case, the rivers and the river and streams there, but written for ecosystems as a whole within Tamaqua Borough. So the first community in the world to recognize legally enforceable rights for ecosystems passed in Tamaqua Borough in 2006. And then, because the world is a very small place, and sometimes we forget how small, we got a phone call from the Ecuador Constitutional Drafting Assembly, so folks working with the drafting assembly, because the country of Ecuador was actually drafting a new constitution back in 2008. And they had heard about Tamaqua Borough. They had news clippings about what had happened in Tamaqua Borough. And they wanted to write rights of nature into their new national constitution, their federal constitution. So no longer a community of 7,000 or a small community, but big national constitutional stuff, federal constitutional stuff driving this rights of nature concept in. So we traveled down to Ecuador and met with the Constitutional Drafting Assembly. We told them some of the stories that had been happening, some language that was used. We helped them draft some material. And eventually that became a draft of the new Ecuadorian constitution, which was then sent around to the country for residents, voters to vote on and ratify, which it was overwhelmingly ratified and adopted as the new system of environmental law within the country of Ecuador, making Ecuador the first country to actually shift from a property-based system of environmental protection to a rights-based system of environmental protection. So it was huge. And it got a lot of news, MSNBC and the big news outlets covered it. And the first enforcement case was then brought on behalf of that law. So again, Ecuadorian constitution ratified by the public contained language recognizing rights for ecosystems. The question then was, can it be enforced? And that was answered very shortly when two people living along the banks of the Vilcabamba River, which is a big river in the country of Ecuador, sued a local government for the local government dumping road debris into the river, changing its course. And the river argued that it had a right to a certain course and right to flow under those rights of nature provisions in the Ecuadorian constitution. The case was known as the Vilcabamba River versus the province of Loja. And the case name is unimportant, except to understand that the river was the plaintiff. So again, it's hard to get our brains around this sometimes. This was not people as plaintiffs, this was the actual river as a plaintiff. A case proceeded through the court, and the judge eventually ruled on behalf of the river. It thus became the first case in the world in which a judge had ruled on behalf of the river as a plaintiff to order the stopping of the activity that was interfering with the river's flow. So first enforcement case of rights of nature in Ecuador. And then the way this stuff works is that one place does it, boomerangs back to another. Pretty soon, the city of Pittsburgh was interested in moving forward a law banning fracking in 2010 within the city of Pittsburgh. Believe it or not, the fracking companies wanted to frack underneath a Catholic cemetery in downtown Pittsburgh. So, fracking under grandma kind of thing was the talk of the town. But they had signed, the Catholic Church had signed a lease with the oil and gas company to actually drill underneath the Catholic cemetery. City Council was upset, elected representatives were upset. We helped them draft an ordinance banning fracking within the city limits, and then added a provision at the request of some of the city council members about protecting the three rivers, the Ohio, the Allegheny, and the Monongahela River, the three rivers that flow through the city of Pittsburgh, and wrote that into the law. So basically rights of ecosystems within the city of Pittsburgh, which would protect those three rivers. And to our amazement, I think the city council voted unanimously to adopt that ordinance within the city of Pittsburgh, which still stands today. So a ban on fracking within the municipality of Pittsburgh, the city itself, in addition to recognizing rights of nature within the city of Pittsburgh. So what was interesting to us as this concept began to develop, and the city of Pittsburgh became the largest municipality in the United States to adopt a rights of nature law. Today we have about 36 communities across the United States that have adopted rights of nature laws. Folks may be, especially there, might be familiar with the Lake Erie Bill of Rights. I know there are people here that can talk about that or answer questions about it when we get to that point. But the city of Toledo, people within the city of Toledo, February of 2019, adopting a Lake Erie Bill of Rights. So rights of nature embedded into the city of Toledo's code. What was fascinating to us is after those developments, which were all pinned to legislative laws. So actually people drafting laws, putting those laws into place, whether as statutory codes or local laws at the municipal level or constitutional provisions, it was all built on a legislative platform. I don't think anybody really foresaw what was going to happen next, which was that courts in different countries began adopting rights of nature principles as a new emerging norm of international law. So without a legislative platform in place, the Colombian Constitutional Court in 2016 was the first court to recognize that the Rio Atrato, so the Atrato River in Colombia, which is a threatened river, major river within Colombia, actually had rights, so possessed rights. And when asked where those rights came from, because the court was making this proclamation without any legislative law in place, there was no constitutional provisions, no statutes, no municipal laws, nothing to enforce. They simply explained that the rights of nature was a new emerging norm of international environmental law and traced it back to Ecuador and Ecuador's inclusion, and talked about some of the other places where rights of nature laws had been passed. So again, without any legislation whatsoever, courts, by judicial decree, judicial activism, began including rights of nature in their rulings, but finding that in this case, Main River had rights that flowed through Colombia. And then in 2017, an Indian court, a court in India, ruled that the Ganges River was a person for purposes of possessing rights within India. And again, asked about where that authority came from, the Indian court said, well, it's a new emerging norm of international environmental law. As soft as that is, that's where these judicial decrees started coming from, which was judges basically just acting to confer those rights without a legislative platform. Again, in 2018, the Colombian Supreme Court recognized the Amazon and the Amazon River Basin as having rights. So basically some attributes of personhood and having rights, the Amazon River and the Amazon River Basin. And then in 2019, the High Court of Bangladesh, recognizing it as a new norm of emerging environmental law, found legal rights for all rivers within the country of Bangladesh. And then one of the latest developments happened in Uganda, not court-wise, but legislative-wise. They passed the National Environmental Act, has rights for ecosystems within that National Environmental Act. So interestingly, extension of the rights of nature concept without legislative platforms, by judicial decree, by courts finding that it's a new emerging norm of environmental law. And finally, just to finish up with two other things here. One is that the work by tribal nations has expanded as well on rights of nature issues. So we all think about states as having state constitutions. We know the federal government has a federal constitution. Tribes also, as quasi-sovereign nations, have constitutions as well. And they also have tribal laws, which are subordinate to those tribal constitutions. So beginning in 2015, the Ho-Chunk tribe in Wisconsin became the first to consider and take a first vote on rights of nature being included as a tribal law within the Ho-Chunk tribe. The Ponca in Oklahoma were next, so the Ponca tribe in Oklahoma. The Ojibwe, the Chippewa White Earth Nation in Minnesota, passed a tribal law that protected the rights of wild rice, so known as monomen within the tribal context, a cultural staple that is wild rice, and rights of nature being used to protect a specific species, in this case, the wild rice growing on the reservation. The Menominee in Wisconsin, voting that the Menominee River has rights within that tribal context. And the Yurok tribe in California, Northern California, recognizing the Klamath River as having certain rights, basically Klamath River being a person for purposes of parts of the law, as well as having rights. And then most recently, about a month ago, the Nez Perce tribe in Idaho recognized the Snake River as having rights through a tribal resolution then codified within the tribal council. So kind of an overview of the expansion that's taken place, kind of started really small in a small municipality, then went big really fast with Ecuador and the Ecuadorian constitutional provisions. There's now been about 60 enforcement cases in Ecuador around rights of nature, enforcing those constitutional provisions. Then back to Pittsburgh, a big municipality in the United States, out to a bunch of smaller municipalities in the US, and then these international developments in these country courts, which have moved to adopt the rights of nature principles without any legislative provisions, then shifting to tribal nations who have begun to adopt rights of nature law. That's pretty much been the kind of course here, the arc of adoption of these laws. And all to say, 25 years ago, talking about rights of nature, even 15 years ago, talking about rights of nature was laughable to most. Most major environmental groups, most environmental professors, I remember giving a speaking tour 15 years ago with a South African lawyer where we had environmental law professors walking out of the room within the first 10 minutes of giving a talk. The students would stay around, but the environmental law professors were out of there because it was seen kind of as a threat to the environmental law industry and careers that have been built around how this environmental law industry works. But today it's being taken seriously. I wouldn't say it's part of the mainstream yet, but it's getting very close. But it's a whole new model of environmental protection that I think people have begun to embrace. And so the last thing here before turning it over to questions and discussion back to Aubrey is that there is on the November 3rd ballot this year, probably the most important environmental ballot initiative this year is appearing in Orange County, Florida. And so just to give you an idea of Orange County, for folks who haven't been to Florida, we're talking Orlando. So the Orlando area, Orange County, it's a county of 1.4 million people. So one of the biggest, it's the 30th largest county in the United States, the 5th largest county in Florida. For folks that don't know what's been happening in Florida around water quality issues, it's a real shit show in Florida. Between the red tide, the algae blooms, even before COVID, people were wearing masks on the beach because of the cyanotoxins and the red tide and algae bloom stuff that was affecting people. When I was there relatively recently, there were backhoes and bulldozers on the beach taking dead sea life off by the ton. So manatees, dolphins, fish, all the kills that have happened trying to get that stuff and those animals off the beach. And folks may have read a couple weeks ago, Biscayne Bay, so we're talking southeastern edge of Florida, went down to zero dissolved oxygen, 0% dissolved oxygen levels in Biscayne Bay. I don't think you have to be a scientist to know that 0% is a really bad thing because everything that lives in the water depends on that dissolved oxygen table to survive. It went down to zero and there was a massive fish kill. So there's just, too much nutrient loading, too much pollution, too many people, and the current environmental protection regime simply isn't working. People there have gotten pissed off enough to create a new statewide organization called the Florida Rights of Nature Network, which has placed onto the ballot in Orange County an initiative to recognize rights for all waterways within the county. And to my shock and amazement, I think, after doing this work for so long, it tends to make you fairly cynical. But in Orange County, the initiative has now been endorsed by the county Democrats, by the League of Women Voters, by the Florida Conservation Voters, by the River Keepers, by a whole span of different groups that would normally not probably embrace such a kind of cutting edge proposal. But things have gotten so bad in Florida at this point that these groups have come forward to actually embrace the concept and have endorsed it, as well as a bunch of other candidates. The Florida Rights of Nature Network has been endorsing candidates who support this Rights of Nature initiative. There's a bunch of candidates, looks like they're going to win in November, and so that would be a whole new shift to using the state legislature to protect some of these issues. So the most important takeaway from the Florida stuff, biggest municipality in the United States, it will be a huge vote taken on November 3rd. And what they do with that initiative will be to begin to enforce it immediately to protect waterways in Orange against these kinds of threats. The final point here, I know I'm a little over time, but the final point is that people sometimes ask, well, why not work at the state level, or why not work in Congress to advance rights of nature stuff forward? And the answer to that is pretty much because those levels have been openly hostile to any new legal mechanism or legal structure that would threaten most of the very supporters and folks that keep state legislators in office and the federal government, federal legislators in office, but that the work is taking place at the municipal level mostly because there is no other layer that would be receptive to adopting these kinds of laws or enforcing these kinds of laws. And I guess the place we point to is Ohio and Florida. In Ohio, after the Lake Erie Bill of Rights passed, the Ohio legislature passed a preemption law, which sought to prohibit any other municipality from adopting a rights of nature law specifically. And then Florida followed lead. The Florida legislature passed a law prohibiting municipalities from adopting rights of nature laws within the state of Florida. It was signed into law by Governor DeSantis a short while ago. And now there's a lawsuit that's been filed by the Florida Rights of Nature Network against the state, dealing with that preemptive issue and whether the state has the legal authority to preempt that kind of lawmaking by home rule counties in Florida. So lots happening. It used to be 20 years ago, almost nothing was happening. Today, just keeping up with it is a chore, but that's a good thing because there's a lot going on. A lot more people are involved in this work. And I happen to think it's the next frontier for environmental law, moving beyond this environmental regulatory system that we've had, moving towards something else, which is based on rights. Thank you.
Thank you, Mr. Linzey. And I'll open up the floor to any questions. If anyone has a question, go ahead and unmute yourself and ask your question. Anyone have a question for Mr. Linzey?
I have a question. You talked about Orange County in Florida. Are there any other major counties or municipalities that you are kind of looking at and thinking that there's hopeful grounds for new movement in that area?
Yeah, it's a great question. So at any point in time across the US, there are communities that are considering putting forward these new kinds of laws. So there's a cluster of communities in Virginia, in Massachusetts. There are, of course, the 36 communities that have passed these laws previously. We're working with communities in North Carolina, in Texas, in Colorado, in California, and now starting somewhat in Oregon as well. So there's a bunch of places that have expressed interest in this work, but as you can imagine, it takes a serious effort and really serious people and a resourced effort to really pull this off, because you're moving these laws in the face of a hostile legal system and a hostile political system. And because of that, you're inevitably on the defensive almost as soon as you start to draft this stuff. But it's also important, I think, to see it not as sometimes we talk at the 30,000 foot level about rights of nature. We've kind of stopped using that phrase when we do community organizing, because it's really not that 30,000 foot level. It's about what do you want to protect in your community and what's stopping you from doing that. And if you can't protect that river or stream or mountain or forest or whatever the communities come around to protecting by using existing environmental tools, then the community has to devise or create their own. And when they start to create their own, you run into the state government telling you that you don't have the power to do it. You run into court sometimes because you get dragged into court to keep you off the ballot for those issues that have to go on the ballot to be adopted. And so you're automatically operating in a hostile environment. And so over the past 25 years, we may have had, I'm just picking this out of my brain, but a couple thousand inquiries about rights of nature laws. But in reality, only a very small percentage of those actually proceed to move forward with something in a real sense. And I think that you're going to need in the US, it's still the beginning of this work, because a lot of people, I'd say most people, haven't heard of rights of nature. They have no idea what it is. It's a new thing still. And I think because of that, we're at the beginning, but what you need is thousands of communities around the United States who are passing laws and openly challenging the state's use of this regulatory system to force these unwanted projects down their throats. And I think, Western communities start in that place, our cities, towns, villages, and counties. The tribal nations start in a different place. They're coming at it pretty much from the 30,000 foot level, but are also trying to stop specific projects in their on reservation land or projects that are outside of reservation land. And so it's a complicated mix, but it's really about people recognizing a failed environmental protection system, moving to a different system, and then having the confidence and the power to actually combine together to move something forward and put it into law. Because I don't know about you guys, maybe not, but I've been to a lot of conferences where people talk about how much they love nature, and I love nature too. But I'm tired of the speeches about loving nature and, we all have to say a prayer or do yoga or whatever the hippy dippy thing of the moment is. But the fact is that until it's driven into law, it doesn't exist. Rights of nature has no rights by default. They have to be driven into law. They actually have to be communities that say, we believe this value and this value high enough, just like human civil rights, that we're going to drive this into law. And that takes a special kind of person, takes a special kind of community, but it's all about kind of volume, you know, people coming to this understanding, being willing to go through a process and then passing it into law. So it's an organizing process for the most part, but more and more people, as they learn about it, are beginning to travel that path.
I have a question.
Go ahead, Kenda.
Thank you. Thanks, Thomas. I wonder what you could tell us about rights of nature conservation easements.
Yeah, so it's a brand new kind of cutting edge area of recognizing rights of nature if you're not in a community that's passing a law. So if you have a 10-acre piece of land, and Kenda, you've been through this, so this is all recap for you, but for other folks, that if you have a parcel of land, like Kenda does, and you would like to recognize rights of nature on that parcel of land, there's two ways to do it. One is to go to the local government that you live in, so the county government or other municipality, and then pass a law that applies to all land in the community itself. So it applies equally across all parcels of land within the county or the other municipality. The thing that we created when I was with an organization known as the Community Environmental Legal Defense Fund, which I'm no longer with, and have left to create the Center for Democratic and Environmental Rights, was to develop an easement process whereby landowners could take traditional conservation easements, which have been around for a while, 40 years in most places. And traditional conservation easements were about if you had land and you wanted to permanently protect that land from development, then you would sign an agreement with a nonprofit land trust organization or with government in which you give away your development rights, your right to develop the property. So kind of going back to this bundle of rights concept, you're giving away one of those sticks in the bundle of rights. You're giving away your right to develop the property. That's how conservation easements have traditionally been used over the past 40 years. We supercharged the rights of nature, or the traditional conservation easement, to include rights of nature. So that if you're a landowner, not only can you lock up your land from future development in perpetuity through using these traditional conservation easements, but you can also recognize the rights of ecosystems on your parcel of land by integrating what would normally be a law, this rights of nature stuff that's been passed into law in various places, integrating it into the traditional conservation easement to, in essence, recognize nature's rights on that particular parcel of land that you own. So that's, for a lot of people, that's like drinking from a fire hose sometimes to understand all that stuff. And it's a complicated process, but suffice it to say is there's a way to create and recognize legally enforceable rights for nature by using this traditional conservation easement process. But the downside of it is it only applies to one parcel of land. It only applies to that parcel for which you have the deed, which you're then attaching the conservation easement to. So that's the downside. But the upside is if you're in a community that's openly hostile to rights of nature concepts or passing a law containing rights of nature, that you can create that on your land without anybody else's permission. You don't need the county to pass a law. You don't need municipal officials to approve it. It becomes a thing you can do on your own to create rights of nature on your parcel of land. So it's kind of it's a natural extension of the work, I think. And in fact, the work that I did on rights of nature easements is now being copied by some climate folks who are writing climate protection provisions into traditional conservation easements. So it's kind of a flip or a accelerant on the type of model that we pioneered with the rights of nature conservation easements. So it's an exciting new field, and the landowners that want to go beyond just wrapping up from development can create these rights of nature structures on their land through the rights of nature conservation easements.
Let's see, we have a chat. Tish Odell says, and isn't it true that all but one Democrat voted for the preemption of rights in nature in Florida? So has the Democratic Party in Florida really endorsed the rights of nature?
Yeah, it's a great question. I was involved in some of those committee meetings where the Democrats were voting to preempt. And we have to understand, and I know Tish does, that this is a complicated world, and that there are different folks in control of, like the Democratic Party of Florida, that are necessarily the legislative elected officials on the floor. So I was heartened to learn, in fact, this just happened yesterday, that the Orange County Democrats, so the County Democratic Party in Florida, actually endorsed the Rights of Nature initiative. And the Orlando Sentinel, a major US newspaper, also came out and endorsed the Rights of Nature initiative in Florida yesterday. So it's been fascinating to watch. And we also have to remember that in 2016, the Democratic National Committee, the DNC, placed Rights of Nature language into their national democratic platform around tribal indigenous use of rights of nature. That's something I didn't know until last year when we went back and started surveying stuff, because this year there was also a proposal to put rights of nature into the national democratic platform. It failed. But there's a history there, 2016 at least, of putting that language in. It's not like the Democrats are going to save the world. I mean, just to, I think most people who work in environmental politics or on radical edges of activism and civil disobedience understand that the Democrats are not going to save the world. They're better than Republicans in most places, but for this stuff to take hold, it's really got to be people in the communities who are working on it, who match up with like-minded people in, state Democratic parties or county Democratic parties. There's also an environmental caucus within the Democratic Party of Florida, which has endorsed. There's a rainbow caucus of the Democrats that has endorsed. I think we have to stop looking at the Democrats as this kind of monolith, because there are individual people who are trying to do the right stuff within those systems. And we need to actually join hands with them to do what is unlikely and has occurred in Florida, which I hope occurs more places, which is rights of nature is finally moving into the mainstream and gathering support from these entities and groups that normally wouldn't have touched it with a 10-foot pole 10 years ago. So we have to decide whether we're going to remain small and didactic, like a small number of people holding hands talking to each other, or whether we're actually going to take this concept and liberate it and release it into this broader world while maintaining control so that it doesn't get diluted. That's the challenge. And so I wouldn't look to any group, Democrat group or otherwise, to be the savior. That's not the point. The point is to liberate this community activism so that it gains mainstream support. And when it's embraced by whoever, for whatever reason, we need to be supportive of that. Otherwise, we're just in a small room talking to each other, and that doesn't really do the earth any good, I don't think.
Thank you. Any other questions? Professor Gilbert?
Mr. Linzey, thanks very much for, we're glad we were able to attract you back to Toledo again, at least virtually. And I really appreciate the work you've been doing and enjoyed your talk today. Certainly there's so many questions or so many of these rights of nature ordinances, community rights ordinances. Have any of them been upheld? That's not the right question. Have any of them been enforced? Have been successfully enforced anywhere?
No, the answer is no.
That's disappointing.
It is disappointing, and it's a disappointment that's widely shared and frustration. But there have been a couple of attempts to enforce. There were 2 attempts in Pennsylvania to obtain intervention status for ecosystems in a community in Western Pennsylvania. There was also a lawsuit that I was involved in somewhat directly, brought on behalf of the Colorado River versus the state of Colorado, dealing with the interstate compact, dealing with water allocations for the Colorado River. That case was pulled by the Maine attorney that was working on it under threat of sanctions from the Colorado Attorney General's office, just to let you know how contentious this stuff can be. And as I understand it, I haven't been involved directly, but there's also enforcement action that's been filed in Ohio that just got some life from an appellate court. But I don't think there's any expectation that that's going to actually result in whether we want to characterize it as a legal enforcement action with actual consequences or results. I think the holy grail is enforcement, because otherwise it just sits there or it gets overturned. I think in Florida, we're looking at a different kind of organizing, which is that they're listing out enforcement actions now. If this Orange County initiative passes, might be the first place that enforcement action takes place in the U.S. Keeping in mind, of course, that even though the U.S. has struggled in actual maintaining enforcement actions on behalf of ecosystems, other places have not. So these 64 cases in Ecuador that have been enforcement actions, and enforcement actions brought in some of these other countries that resulted in the Rio Trato decision and others. We are stragglers in terms of enforcement. So these laws are passed. Sometimes they're effective at chasing the project off because the law is passed itself. Like in Pittsburgh, the Pittsburgh law has never been overturned, but at the same time, it's never been enforced either, despite our best arguments to the council to do that against upstream fracking companies that were damaging the rivers as they flow through the city of Pittsburgh. But the quick and easy answer is no. But there's stuff in the pipeline that may change that answer over the next, in the foreseeable future.
Thank you. Anyone else have a question? Last call for a question. And if not, I have one. Seeing none, I was going to ask you, Mr. Linzey, since we do have law students in here, do you have any advice for law students who might want to go into the type of practice that you do?
Yeah, I got asked that question speaking to the undergraduate group as well. My answer to that was don't go to law school. so
Too late.
My answer here is probably different. But for folks that want to do this work, you really have to create your own organization to do it. There's very few organizations out there that have the capacity or the resources to hire new lawyers coming out to do this kind of work. And, I did it coming out of law school. As soon as I came out of law school, we created the nonprofit law firm. I don't think it's hard to suggest that as a career choice to anyone, because the first year I made $750 with loan repayback from my law school for my law loans. But it's a difficult hill to climb. The problem is when you go to work for existing environmental groups, they're not going to have you doing any cutting edge stuff of this nature. You're going to be stuck in the regulatory permit stuff, permit applications, counseling corporations on environmental compliance, that kind of stuff. And so you really need to create it on your own. And that's a really tough hill to climb, but it means, being confident and courageous enough to say, we're going to do this. There are other groups working on rights of nature stuff that have been active, like the Earth Law Center is a committed group of folks that weren't around 10 years ago. The Climate Defense Project, which works on defending individuals who've been arrested for doing civil disobedience around climate change actions. So there's a couple groups in the periphery that have been starting to work on this new kind of cutting edge of environmental law. But I think my basic advice is give up hope that any of these larger institutions or law firms, and I still have friends, I have colleagues in NRDC and WWF and EDF and all the big law firms, I still talk to them. But the fact is that their transition to anything that resembles a rights-based environmental law protection approach is a long way away. It's starting to happen, but it's a long way away. And if you want to do this work, unfortunately, it means kind of paving your own path, walking your own path, and probably creating your own organization to try to work on this stuff, because unfortunately, it's still not institutionalized, even though some of the people working on it should be institutionalized. The approach is not at this point. So I think as tough advice as that is, that's probably where we sit.
Well, excellent. Thank you, Mr. Linzey, so much for coming and speaking to us tonight. This is where I'd normally ask everybody to thank you with applause, but I'm not sure that we can do that this way. So is anybody have it? Oh, there you go, Kenda. I'm still learning Zoom myself. But thank you again. And if there's no other comments or questions, we can sign off.
Great. I would just add, Aubrey, that we have a newsletter available for folks that want to be updated on recent rights of nature developments. And so I posted that in the comment section, chat section. And thank you, Aubrey, for making this happen.
Goodbye.